Hello and welcome to the Center for Medical Justice. I'm here with Dr. Rifai, and he's going to tell us about what he's been going through. It turns out that in the federal system, as they start prosecuting doctors, it's not just innocent unless proven guilty. Innocence is not an option. Even if you're acquitted, they still try to persecute you and take things away from you. And Dr. Rifai is, I would say, the pioneer of what I'll call telepsychiatry, which is an amazing way to reach out to patients and provide them important care that they need. Dr. Rifai, thank you so much for being here today.
Thank you, Dr. Parker. Thank you for having me talk to your audience. It's a pleasure. It's a privilege to be in the company of Captain Lonnie Joseph Parker. It's an honor to be talking to you. I just want you to know that we are all behind you, and we're rooting out for you, and you will not be left alone. The medical community will continue to take care of you and be with you in your time of distress that's caused by the unjust persecution from the federal government.
Thank you so much, sir. That's very meaningful, and I appreciate that.
Just a recap for the audience of where we left. I know we have talked about my trouble with the United States Department of Justice that started almost now 8 years ago, with them starting an investigation into my pioneering work on providing psychiatric services by telehealth to indigent rural Pennsylvania patients. I'm not sure why I was picked, but my ethnic background, my national origin, my religious background, and my name, I think, are big factors into why I was picked as somebody that is whose number has come up for prosecution. The government's initial theory from the get-go was that we were providing services, but we were billing for higher level services, and that we were billing for services that were not provided. That was the whole concept of the government. They obtained a medical record from us in 2017, and we are going to be talking about this hopefully in the future, but the federal government referred our medical records to a contractor that was supposed to do a review of our records. And we never were informed of the results of this review of the record until 2024, from 2017 to 2024. But in trial, we demonstrated that this contractor completely fabricated the results of this audit. A complete fabrication. They included dates that I never billed on patients, that I never saw patients, as dates that were presented by the government as fraudulent services. And we presented that in trial. And the jury saw that, and that was one of the main reasons for acquittal, is that the government fabricated the entire basis of this prosecution. At one point, the government probably realized that their evidence was quite weak. They asked for our documentations. They received voluminous documentation. They received extensive medical records, more than 1 million pages of medical records that they requested. And obviously, sometime around 2021, they realized that their case was very weak. And so they had to dredge up some additional evidence. And what they did is they looked for the Drug Enforcement Agency. And they said, well, let's look at, this is a psychiatrist, he must prescribe controlled substances. Let's look at his prescribing profile. And we are a busy psychiatric practice. They looked at the numbers and they said, aha, he prescribes 100,000 pills of Adderall per year. That is a good reason for us to go after him. Now, they presented that in court, but we countered that those 100,000 pills of Adderall, the majority of them, more than 80%, are medications that were prescribed for children and adolescents under the age of 18 who had legitimate attention deficit hyperactivity disorder and who were using these medications under the supervision of their parents to excel in school and to be functional in life. They never mentioned that fact. They said, oh, 100,000 pills of Adderall, he must be prescribing thousands of fraudulent prescriptions. So the Drug Enforcement Agency looked for, I know in other cases with other physicians, they looked for patients who have legal issues. I know they recruited patients who had legal issues and wanted relief on their legal issues. In my case, they went to a local police department and asked for a female police officer to come undercover in my office. And they asked this police officer, and I'm going to mention her name because it's public record. Her name is Officer Gretchen Kramer from the Bethlehem Township Police Department. They asked this police officer to come undercover in my office. And they called my office. Mind you, this is in the height of the COVID public health emergency in 2021. The Department of Health and Human Services, instead of working on COVID relief efforts, or they're just investigating a doctor for issues related to healthcare fraud that are unfounded, that are fabricated, and they're involving the DEA to also continue to persecute this doctor. This doctor, who had been participating with the Pennsylvania Department of Health in vaccinating the people of Northampton County, Pennsylvania. And we provided 4,000 shots of Moderna COVID vaccine free of charge to the members of our community. So the police department, Bethlehem Township Police Department, under the tutelage of the Drug Enforcement Agency, decided to send this police officer as an undercover police officer to my office. They called my office and obtained an appointment. They indicated that this person does not have insurance, and we inquired whether this was a professional, and they indicated that they would be paying cash. During the appointment, my staff obtained initial information trying to figure out why this person wanted to be seen. And they had to check with me because we were not taking new patients. But they indicated to me that this person was a professional. She indicated that she was a hairdresser. She was a professional hairdresser, and she was suffering with attention deficit hyperactivity disorder as an adult. She ran out of her medications. Her doctor retired, and she moved to this area, and she is seeking help and begging us for help. She was on the phone with my staff in April 2021 for about 30 minutes. And she gave him all the information. My medical assistants obtained all the information, and an appointment was set up for her in May 2021. She presented to the appointment. The appointment was recorded by the Drug Enforcement Agency as well as Bethlehem Township Police Department. And to the surprise of the DEA and the Office Inspector General, Department of Health and Human Services, and the United States Department of Justice, their expectations was that this undercover police officer was going to present to my office. I was going to evaluate her for maybe 3 to 5 minutes, give her a prescription for cash, and send her on her merry way. Well, the police officer spent 100 minutes in my office. 100 minutes. This is in addition to the 30 minutes initial psychiatric evaluation. So now we're at 2 hours and 10 minutes of evaluation for this police officer. She received psychiatric evaluations. She received tools to assess her for depression and anxiety, She received a computerized test for attention deficit hyperactivity disorder. She received a urine drug screen. And ultimately, we decided that she had symptoms of attention deficit hyperactivity disorder and that an initial trial of a stimulant would be appropriate at a lower dose than she was requesting. She was requesting 30 milligrams. We started her at 5 milligrams twice a day because I felt that she had signs and symptoms of attention deficit hyperactivity disorder. She followed up with our office in June and July and August with subsequent visits through telehealth assessments. And basically, she was lost to follow-up according to the DEA, but we actually terminated her from our office because we found out on her follow-up urine drug screen that she was using cannabis. All of these details are that the DEA and the Bethlehem Township Police Department and United States Department of Justice are disputing. So the case ends there. August 2021, we fired this patient. We sent her a letter to her address, her fake address that she gave us, and the issue ends. The Department of Justice informs me in December of 2021 that I was a target and that I was under investigation for issues related to healthcare fraud and prescribing of controlled substances. And then an indictment came in November of 2022, so like almost a year later. But there were no charges of any issues related to controlled substances. It was just the healthcare fraud. Now, mind you, in between that, June of 2022, the Ruan ruling came. So whether that had to do anything with the case, I am not sure. There's also the tireless advocacy of my attorney, Mr. Paul Hetznecker, who advocated for me. He would send a letter to the Department of Justice every month in that period between December 2021 and November 2022, a letter every month with information, with challenging the notion that the Department of Justice had no case to prosecute me, and that if they decide to bring this case to trial, that he's gonna beat them, and the jury is gonna find his client not guilty. The Department of Justice did not heed Mr. Hetznicker's letters and decided to bring an indictment because there was a new U.S. attorney that came on in July of 2022, Jacqueline Romero. She was originally a healthcare fraud prosecutor in New Jersey and came to the U.S. Attorney's Office in Eastern Pennsylvania. So she said, we're going to prosecute this case.
No.
And fast forward to the trial, I was found not guilty of the healthcare fraud allegations. Now, in between that, a year after the indictment, the DEA woke up out of their slumber and said, well, we want the record of this undercover police officer, Gretchen Kramer, whom I saw 2.5 years ago, 2.5 years earlier in 2021, 2023. They said, we want her records. And Mr. Chapman was engaged to represent me for that issue, separate from Mr. Paul Hetznecker, who was my attorney. And he connected with the Drug Enforcement Agency and said, my client is under criminal indictment, and you are asking for a medical record of a patient. We want to make sure that his Fifth Amendment rights are protected, that he's not presenting evidence that incriminates him. And if you're going to use this is going to be only for an administrative purposes for the Drug Enforcement Agency. The agent involved sent back to Mr. Chapman in writing and said, we're going to use this only for administrative purposes. It's not going to be used for anything else. So 2 months later, I receive a letter of an order to show cause from the Drug Enforcement Agency indicating that they believe that everything in the record is fabricated. According to their recording, everything in the record is fabricated. That I received the request for record, that I freaked out, and I fabricated the entire record.
Now, I've got a couple questions. This is interesting. One, did that person lie to you during your interview and evaluation?
Not just that she lied to me, she admitted on the stand in a federal trial that she lied about everything. She lied about her name, she lied about her address, she lied about her medical history. She indicated in writing, we have her testimony, we have you in the transcript. I'll send you the transcript. She said, I made things up as I went along. So my attorney said, well, so you don't remember what you said? And she said, oh, no, I don't remember. I just made things up as I went along.
Now, one of the things I have a problem with is the Ruan case said that unless a doctor has criminal intent, knows what they're doing is wrong, and chooses to do it anyway, they cannot, should not be prosecuted. So here we have a case of someone coming in. Now, if a patient lies to the doctor has no choice but to assume those statements are factual unless you have extraordinary evidence to the contrary. So if an adult comes in and says, I can't focus, I have these issues, you will diagnose them with something they don't have. Just like if a patient came into the emergency room and said, I have crushing chest pain, and they did Levine's sign, I have crushing chest pain right here on my left side, and I can't breathe. Of course, they're going to get a full cardiac workup. Is that doctor then subject to arrest and prosecution for fraud because he believed the patient? So this looks to me like a crime creation industry.
Yes. So the police officer, I met with this police officer for 35 minutes. Now, part of the case of the fraud case is that this Dr. Rifai spends 1 or 2 minutes with the patient and bills for a 30-minute visit. But what they presented, the video they presented in trial, was 35 minutes. My attorney was saying, this is going to help us. We want them to play the whole thing. I challenged this police officer. I said, where do you live? And she was a police officer in a different police department. I know exactly where she's talking. My kid's school is across the street from the address that she gave. She said, I live in this address. So I said, you live in this address? She said, oh, yes. I have a lease. I sublet from this address. I said, okay, what kind of work do you do? And she said, I'm a hairdresser. I said, okay. We go to the Pennsylvania Department of State Professionals Registry, and we look for her name. And there is a hairdresser, licensed hairdresser, who has her name and lives in our area. And we included that in her chart. So her informations are corroborated. And in trial, she was asked, did you know that there was a hairdresser in the name that you made up? And she said, no, I did not know. And she said, did you know that Dr. Rifai was checking that you were actually a hairdresser? You were who you were saying you were? And she said, no, I didn't know that. So this police officer, simpleton police officer, because she used her own personal information. So when she came in, she was so confused. This was her first undercover health operation. She gave us her own date of birth. She couldn't even make up a date of birth, if a imaginary fabricated date of birth. She gave us her own date of birth, this police officer. And she couldn't make up things. So what she ended up doing is giving up details of her own personal life, her own personal history. And some of this we were able to corroborate later on, and I'll give you the story on that. So we ended up with this police officer who came I diagnosed her with attention deficit hyperactivity disorder. She received a starting dose of ADHD medication. She was monitored appropriately. We found out on follow-up urine drug screen that she had cannabis. We treated her appropriately. We sent a discharge letter because we didn't want her to be on cannabis because she didn't have a cannabis card in our state. And then when the DEA and the Department of Justice requested her record, they said, Dr. Rifai fabricated everything from A to Z. Well, my lawyer asked her, so your date of birth is not fabricated. This is your real date of birth. So how is the government saying that this chart is fabricated? There's one piece of information that is the truth. Her date of birth is not fabricated. And she said, well, I guess, yes, that's not fabricated. So the government's description of the chart as being fabricated is not true. And she said, I guess, yes, it's not true.
That would be an extraordinarily accurate guess for you to come up with a 1 in 300. Well, it's actually much less because you don't know within plus or minus 3 to 5 years how old someone is.
Yes.
So, you know, that would be a 1 in more than 10,000 chance hit that you would get that accurate. So they were willing to lie and say that that chart was fabricated. And here's an important thing I want to get across to our listeners. You are not facing the truth in court because you can defend yourself from the truth because you know what it is and you know you've done the right thing. You cannot defend yourself from a lie because a lie is infinite. They can lie about anything. So you've got the chart saying, look, I did a good job on the chart. And they say, oh, that's a fake chart. And you're saying, what the heck? Why would, you know, now you've got to drop back and try to defend something that they know is false. And that is what really burns me, is that if you go into a doctor's office with a wad of cash and say, hey, I want some Adderall, can I get some of the 30 milligram tablets? And he says, sure, they're $30 each. You say, okay, I want 100 of them, here's $3,000, right? Or however it would work out. I think I did my math. No, not my math. My math's right. You do $3,000, they take the $3,000. Okay. That would be a legitimate undercover operation. When they come in and lie and say they have symptoms, doctor, I have pain. Doctor, I have attention problems. Now it's not just entrapment, it's absolute fraud. But I have another issue. An undercover investigator came into my office, received a physical exam, was denied opiate medications because I didn't feel like his fabricated medical record and imaging justified it. I couldn't get the tape. I couldn't get the recording. How did you get this recording?
They presented it. They foolishly thought that this was going to bolster their case. Their argument was, look, what's in the chart doesn't match what's in the tape.
So they were thinking that they could just say that the chart was fabricated because she's willing to testify that it doesn't match, but yet the date of birth got her caught up.
However, so part of the criminal trial was that the prosecutor received from the DEA, despite assurances to Mr. Chapman that the material from the DEA was only going to be used for administrative issues, the prosecutor in the criminal case received the entire file from the DEA. Okay, and they petitioned to use it as a 404B material, so evidence of prior bad acts.
So let's use that. Let's take a close look at that and the importance of that. So quite often the DEA will go to a medical board and pressure them and either say, give us some doctors, or we're looking at this doctor. You might want to look at him too. So the medical board will then request records. Those records are for administrative purposes released to the medical board. Then the DEA can subpoena them from the medical board, and they've got a double hit. They can go in front of a jury and say, oh, look, the medical board was already looking at him. He's got a troubled past. Mm-hmm. And now, you know, we're looking at him too. So it's a double hit. They pretend that the medical board was looking at you totally without any input from them when actually they directed the board that direction. And in this case, this is an administrative hearing. This is a DEA hearing where they're saying, we're going to look at your prescribing certificate. So we
Yes.
need this for administrative purposes. And then after saying they will only use it for that purpose, which is important because you have the right not to testify against yourself, your Fifth Amendment. And so you don't have to turn that record over to them if they're going to try to prosecute you with it. They say they're not, and then they do. So at what point can you trust anything that they say, or can you?
Let me add to this story. So they and my attorney, Mr. Paul Hetznecker, used this word accurately toward the end of the trial. The government and the DEA hoodwinked my criminal trial judge, the Honorable Jeffrey Schmel. And they told him, listen, Judge, this doctor is crooked. He fabricated this entire chart. And here's the video, and we want to bring in this material. And my attorney, Mr. Hetznecker, as well as Mr. Chapman, had argued that there's Fourth Amendment issues with the administrative subpoena to obtain records to be used in a criminal trial, as well as Fifth Amendment issues. The judge kind of struck a middle ground and decided to allow the chart to come in, decided to allow the police officer to testify, but only about medical documentation issue. He excluded the prescribing issue. He said you cannot talk about the legitimacy of the prescribing. You are just talking about, you think that your chart is fabricated. You're only going to talk about that. That's the whole testimony. You show the interview, you show the video interview, and you show the chart, and you say, look, we think this doctor fabricated this entire chart. However, because of this entire controversy, my attorney, Mr. Hetznecker, filed an additional motion to ensure that Brady and Jenks, as well as all discovery, be presented, and that they should be very severe sanctions to the government if they hide any evidence. This was on the eve of the trial. After jury selection, on the second day of the trial, the government miraculously presented a report from Bethlehem Township Police Department that includes a description of the entire undercover operation. This wasn't a DEA document. This was a document from the police department. In it, the Bethlehem Township Police Department admits that they lost a recording of 30 minutes of encounters with my office. So the initial encounter where my office obtained her history, where she admitted she made everything up, was lost. We also found that the officer, by her own mistake maybe, sent us a picture of her cell phone, communicating with the officers from her police department about her entry into our office and about her exit from our office. And these entries were timed. And we looked at the time, there was 100 minutes of an encounter. And we looked at the tapes, there were only 75 minutes of tapes.
Now, do you think this was lost, or do you think it was lost because mysteriously anything that will truly help you somehow is only found at the very last minute or not at all?
This was doctored. This was doctored. The DEA, which is part of the United States Department of Justice, the DEA agents in cahoots and under the direction of the prosecutor in the case, doctored these interview records. We think the 30 minutes maybe was lost because of the incompetence of the Bethlehem Township Police Department, but the other 25 minutes was probably lost, was probably deleted or doctored by the DEA.
Well, let me tell you one thing that they've been caught, well, that they're doing. I don't know how much they've been caught doing it. What they will do is if a compromised patient or an undercover person goes in, they will have the person record things on their personal phone. If the doctor says anything incriminating, they will say, send us that video, that tape. If the doctor shows honorable intent and due diligence, they will say, we don't need that. So that allows them to filter out any evidence that would be helpful to you, because they can honestly say, we never had that. We never had a recording from that. Well, no, because you told them to lose it, right? So I am positive that they sent patients into my clinic being recorded, asking for things, not getting it, and mysteriously that never showed up in any of the discovery.
I know, because I remember one particular patient who was probably sent by, he was probably an undercover person for Blue Cross Blue Shield, and he wanted benzodiazepines. And I said, you don't need benzodiazepines. I'm going to start you on an antidepressant and buspirone. And he got really mad. I am quite sure that he was recording. And he said, what are we selling here? He came flat out. He said, what are we selling here? And I said, we are not selling anything here. This is a respectable doctor's office. You need to take yourself and leave my office immediately before I call the police. And that's how this interview ended. And he said, well, I don't want you then to bill Blue Cross Blue Shield. I said, I won't send a bill to Blue Cross Blue Shield. And we never sent a bill to Blue Cross Blue Shield. They were probably counting on us sending a bill. I never sent a bill. And we never saw that recording. And they're probably going to say it didn't exist.
Right, exactly. And let me bring up something. We act in manners that we think can't be twisted wrongly. But here's a problem. If they ask for a refund for their visit or that you not bill, they can then argue that you did not accept payment because you did not prescribe the medication. Mm-hmm. If you do bill, then they will say it's fraud. And no matter what you do, right, they will twist it.
Absolutely.
So I only took patients who had been seen by specialists such as yourself. They were on controlled medications. They had to have seen a specialist, already been to treatment. And I would continue their treatment if I thought it appropriate after review of the records. They twisted that in court into he only takes patients already on medications because it's easier to get them addicted. And if it hadn't been such a tragic thing, I would have thought that is just masterful. I would have never thought to twist something, to lie so deviously, right?
Let me even tell you something that is more legitimate. On that patient, I checked the PDMP, the prescription database, and found that she was not on any controlled substances. What they twisted that into, well, look, he checked and didn't see that she was on Adderall, and despite that, he gave her Adderall. So no matter what you do, I mean, a legitimate activity. Exactly. I checked the PDMP, she's not on any controlled substances, and then she indicated to me that she hadn't been on medications because she wasn't doing very well in her life, and that it was at another state that she was getting her medications that wasn't included in the PDMP. And so basically, no matter what you do, even the most legitimate activity that you do could be twisted as something against you.
Now, I want to bring up something and make sure our audience understands that you're board certified in internal medicine, neurology and psychiatry, psychosomatic medicine, and addiction.
Yes.
And somehow you're not qualified to start somebody on an ADD medication when
that's their argument.
Exactly. So
you're without any physician input. This is all the prosecutor and a DEA agent and a lawyer for the DEA. There's no doctor that looked at my chart and said this was appropriate, inappropriate prescribing. This is just the DEA agent, the undercover police officer, all of them high school or maybe 2 years of college, and then a prosecutor and a DEA attorney. That's all who's judging me.
And without a medical license or any medical training, they get up and tell the jury that this person did not need that medication. Is that not practicing medicine without a license? Because one, they are diagnosing, and two, they are determining what treatment the patient, quote, should have had.
Let me tell you, I'm smiling because this story is gets into the unbelievable train track. We'll talk a little bit more. So what happened is during during the last 3 or 4 months of my criminal trial, the DEA was revving up to do this administrative hearing, and they were hoping that they were going to do the administrative hearing and revoke my DEA registration before the trial. But they met their arch nemesis, Mr. Ron Chapman II, and he took him on a tailspin of requesting appropriate documentation from the DEA, requesting, we had an expert that was ready to testify. One of the things that they said was against me was that there were some patients who were traveling about 50 miles to come see me. And they said that was one of the that was one of the kind of the warning signs. We were able to find one of my patients who traveled 60 miles to come and see me. Who do you think that that patient was? He is the district attorney of that county. And he traveled 60 miles to come see me. And they were going to present evidence in the DEA administrative hearing that I was basically recruiting patients from afar. And our witness was going to be the district attorney of that county who came and saw me and received controlled substances.
Let's explore that a little bit, because that's one of their 12 criteria. We filed a 404B saying, what the heck is a pill mill? You've called Dr. Parker's clinic a pill mill. They came up with 12 criteria, none of which applied to my pill mill. So at trial, they said he's a stealth pill mill. He's purposefully avoiding those 12 things to slide under the radar. So it's like he's purposely not breaking the law so that he won't be prosecuted. We're going to get him anyway. But in your case, I sense, and from talking to you, you are a compassionate person. You're an amiable person. They seem to not understand that not every doctor or healthcare provider is the same. Patients suffering from addiction, chronic pain, and psychiatric problems are used to being treated horribly. So when a physician is compassionate to them, they will drive 200 miles to see that doctor to be treated right. And who is the DEA to say that someone can't drive 60 miles to see a specialist with your qualifications?
And I'm amiable, but I follow all the rules and regulations. So in this lady's case, we tested her to the wazoo. We did a urine drug screen. We checked the PDMP. She was in my office for 100 minutes. We had talked to her for an additional 30 minutes before. And their whole argument is Dr. Rifai sees patients for 1 or 2 minutes and prescribes to them willy-nilly fraudulent controlled substances prescriptions, which wasn't even proven by the evidence. So basically, Chapman was able to file the civil action against the United States Department of Justice and the Drug Enforcement Agency to delay the hearing, the administrative hearing with the DEA for show cause until after the criminal trial. And what happened in the criminal trial, we got this significant evidence from the Bethlehem Township Police Department, their report. We also got the testimony of the police department. She was planned to be the star witness of the DEA hearing. And they found out that they didn't have a very good witness. They looked at her transcript and they said they didn't have a very good witness. So the DEA started trying to weasel out of the hearing. And they started creating significant roadblocks. And Mr. Chapman subsequently asked for an injunction against the DEA and asked for a stay because there were several Supreme Court cases that are coming up. Jarkissi was one, we've talked about that. And Lopez was another one that we've talked about also.
Right.
And then United States v. Trump, where Justice Thomas commented about his doubtfulness about the appointment of a special prosecutor, as well as the appointments of administrative law judges, whether that was constitutional or
I
unconstitutional.
see, because the DEA judges are constitutional law judges. Well, let me ask you something about that. I find it very interesting that cannabis showed up in her drug screen, and I'm wondering if perhaps they had to say they felt they had to say that the chart was falsified because otherwise you've got a police officer using an illegal substance or using a substance illegally without a medication card. And I'm sure the DEA kicked her door in and came and took her away immediately.
No, no, she's still there. She's still an investigator.
I was being facetious because when
Yes.
it comes to themselves,
They said I falsified that. I fabricated that. She was never in my office. I made that whole thing up.
Now, there's two things I want to bring up. They constantly prosecute doctors saying they knew, should have known, or were willfully blind to whatever opinion they pay for. Someone with some credentials to get up in court and say you should have done. Are they not being willfully blind to your innocence? If not, I mean, I think it's absolutely criminal. I think what they did was criminal. They had absolute evidence of your innocence. They allowed people to get on the stand to get your indictment. They allowed people to lie about you when there were records in their possession proving those statements were false. That's suborning perjury. And if they
not a crime for the Department of Justice, just crime for you and me.
Exactly. I like to say there's not two systems of justice. There's not justice at all right now. Now, the second thing I want to say is that the circuits have been you mentioned the Supreme Court, the circuits have been very haphazard. Some of them are completely ignoring Ruan. Others are using Ruan the way the Supreme Court in a 9-0 ruling with a divided court, divided like it hasn't been since the Civil War, probably. With a divided court ruling 9-0 that Ruan says a doctor must know what they're doing is criminal, which is why when they lie to you, they throw that out the window. But besides that, the Sixth Circuit said that a doctor can still stay in prison and you don't have to prove that he truly knew his actions was criminal because he had spoken to his medical board and admitted fault. Admitted that there were things he could have done better. You're taking what all doctors should do, which is look at how they can improve themselves, and elevating it to a criminal act if you admit that there's anything that you could do better or that you could learn more, when in actuality, when it comes to a science as complicated as medicine, there's always more you can know. There's always something that you could do better, even if you did it perfectly at that time. There will later be information coming out to show that might not have been the right thing to do, right? I mean, doctors prescribing thalidomide weren't trying to cause harm to the fetus, right? But they once it was found out, of course, they stopped, but you don't retroactively go back and arrest them. And I would argue that the DEA is creating new laws and rules and then retroactively going back and holding doctors today accountable for patients they treated before under a different paradigm, and they're still doing it unlawfully. Yeah. And your case is unique because you were acquitted. I have to say, that's winning the lottery. It's winning a shark lottery because you still lose an arm and a leg and a whole bunch. But and let's talk about a little bit about that. So you have been acquitted at a criminal trial, yet they are still trying to take something from you and punish you.
But it's even worse than that. So what happened is after the acquittal, the DEA lost their mind. Basically, I mean, lost their mind out of frustration that they couldn't get what they wanted. And so, despite an order from now there's a civil lawsuit against the DEA and the Department of Justice. They agreed to put a stay on this case until the civil case is looked at by the Honorable Jeffrey Schmell, who's the same judge who presided over the criminal trial. The DEA evaluated their cards and created this issue. They said, oh, Mr. Chapman is supposed to give us an update every 60 days. We told him to give us an update. He was late by 39 minutes. We are terminating this entire proceeding. No hearing for you.
Wow.
No, not even hearing for you. We're not even going to listen to what you say. We're going to present this to the administrator to revoke your DEA registration. You don't even get a hearing. This is where we are. You don't even get a hearing. You don't. That's it. It is our word. You don't get to defend yourself. It's just our word. We're going to tell the administrator that you fabricated this entire chart, and you don't even get a hearing. So this is where we are with the DEA. The administrative law judge decided to terminate the entire proceedings. Where does this happen? You're going for a jury trial, and then the judge said, we're done. No jury trial for you. Go to jail immediately. Do not collect 200.
So we effectively are developing in this country what I would argue is a type of star chamber, which was in aristocratic back before the French Revolution. There was this room that these judges would meet in, and they would decide your guilt or innocence. You didn't even know they were there until these guys came and got you, and they said, "Hey, well, you've already had your trial. You just didn't know." And they would go ahead and lock you up, I guess, in the Bastille. And that was one of the things that the French expressed their displeasure at during the French Revolution. So they are denying you a hearing. They are denying you due process, yet they're trying to take your property, something that you own, that you possess, that you've been granted,
Yes.
which is this DEA certificate.
Yes.
And
let me add one more information, because this hopefully after this is done, this is going to be a book, this is going to be a movie, I don't know. So in the several months after my trial, in preparation for this DEA hearing, in preparation for the civil trial, we started investigating this police officer. And we found out that this police officer, Officer Gretchen Kramer, and her family suffer from psychiatric illness, severe psychiatric illness, to the tune of the fact that her brother has probably about 30 federal cases against her. He is suing her, suing other parties. And the court that adjudicated this case was no other than my own judge, the Honorable Jeffrey Schmel.
wow.
And in the court documents, there's like probably 30 cases. We looked at Pacer, 30 cases with voluminous medical records, voluminous evidence. Officer Gretchen Kramer's biological brother, Thomas Kramer, has schizophrenia and ADHD. Her biological niece has ADHD. Her other niece has ADHD. Her other brother has ADHD. And this is all documented by, not my words, medical records, unredacted medical records in the federal judiciary record of these cases that her brother filed against her. We obtained all of these records. They're public records. These are the medical records of the Kramer family. And they all have psychiatric illness and ADHD. And then the DEA is saying, well, Dr. Rifai, why did you diagnose this person with ADHD? You fabricated that entire record. So this is where we are. This is why the DEA went berserk, because they knew that we were on to this evidence. They knew that we found this evidence, and that their star witness, Officer Gretchen Kramer, was not going to be a star anymore. She does have literally ADHD, her and her family, and we're going to bring that up in court. It's not protected information because her brother put out their dirty laundry in federal court.
Right. Once it becomes court record, it's publicly available, even though, they say federal trials are public, but unless you live nearby and are able to get there every day and find a seat, you never get to hear what goes on in a federal trial. You never get to see it.
Sure.
So it's unique for this to happen, for those records to exist. And I have found that they almost always, they are using compromised people that they can pressure, not just the witnesses. They'll use patients with criminal charges hanging over their head. They will use former employees who have been fired for wrongful conduct or have charges hanging over their heads.
Mhm.
But I've also found that quite often the local police that quote call the DEA and report you, right? They're also compromised. The one that called on me was part of the DEA task force. So the
Mhm.
DEA called itself to ask for DEA intervention. He was willing to say that a patient who died, according to the coroner, from a heart condition had died of an overdose, which
Mhm.
makes him practicing medicine without a license. But then a few weeks later, he ran over a stop sign with his patrol car and was charged with driving under the influence. But amazingly, we can't find where they did any drug screens or blood tests or anything.
Mhm.
Being a police officer, he probably refused them because if you know something's going to show up, it's probably best legally to say nope, not taking that test. But they seem so compromised. It, it's almost difficult to believe the levels they will go to and the people that they will depend on to send someone with decades of proven service to humanity to prison on the word of people who are absolutely compromised and either cannot be trusted because they fabricate things or cannot be trusted because they have been threatened with charges. Do
Mhm.
you think uh, couldn't she be charged with a crime for using cannabis while a police officer and on duty and
Well, this would be this would be a good question for her police chief, Police Chief Gotcho of the Bethlehem Township Police Department. That would be a good question for him, whether he was informed that this was going on. So we have a pending complaint against her with her police department. And Bethlehem Township Police Department is not the NYPD. It's a 30 officer police department and a small township with five board of supervisors. We'll see what her board of supervisors would want to do when if they are subject to a lawsuit, and we'll see. But this is a police officer who now admitted that she made up all the information, that she used her own personal information. We have evidence that she has ADHD, and the DEA saw this information and they said, well, no hearing for you, Rifai. We're gonna terminate the hearings. And so we are now in front of Judge Schmel. We have a motion for a temporary, for an injunctive temporary restraining order against the DEA administrator not to rule on this issue until Judge Schmel hears about all of these shenanigans, the Kramer family psychiatric history, and the shenanigans of the DEA, and we'll see what happens.
well
So
let
we have several issues. The main one is the use of administrative subpoena in obtaining records and using that in a criminal issue. So that's Fourth Amendment trial issues. We have the Fifth Amendment, which is due process. So I'm being denied due process by the DEA. And so we are very likely to prevail on these issues, just given the basically where this trial is going, and this civil trial and civil litigation against the DEA and the Department of Justice. And they should hear about it. I mean, it's in the motions. Everything is in the motions. They're going to hear about it, and we'll see where that goes.
Well, and let me bring up that your attorneys are extremely unique in this way and innovative, because a lot of attorneys don't use the Freedom of Information Act, which is enormously powerful. It's how I got the internal affairs report of a patient's death from a jail. They refused, they didn't turn it over to a federal subpoena, but they turned it over to the Freedom of Information Act. And my attorneys threw a fit saying, we didn't tell you it was okay to do that. Why would you not think that was okay? But when it comes to civil suit, I think it's a hugely powerful weapon that can be used to defend the accused that lawyers leave on the table. There's ammunition still in the gun and they don't fire it because in a civil suit, they must give you all the evidence. In a criminal prosecution, the prosecutor is allowed to sort through and choose what to give you and choose what to keep back, which I think is a fundamental flaw in our justice system. So why, how effective have the civil suits been at defending you?
So the remedy for a Fourth Amendment violation, according to the Supreme Court, is a prudential remedy, meaning that they implement something called the exclusionary rule, meaning that if they find that there's a Fourth Amendment violation of my rights, they're going to exclude that chart, and then that makes the show cause hearing immediately collapse because there's no chart. That chart is excluded. There's also Fifth Amendment rights. Basically, they terminated the hearing. So the judge has the option of saying, well, okay, DEA, don't do anything. I'm going to do the hearing. And let's see who you're going to bring in. And we're in a different field now. We're in a different ball field. We're not in front of the DEA in Virginia. We're in front of the circuit court, federal circuit court, in front of Judge Schmel, who's a fair person in Pennsylvania. So the DEA is outmatched. It's in a different ground, and they can't just lie and make up stuff and bring in two witnesses, a DEA agent and a police officer, and say, oh, okay, we're going to revoke your DEA registration. Doesn't matter what you say.
I would argue that most judges that I'm familiar with or that I've seen from studying over 400 prosecutions, it looks to me like they're trying to do the right thing, but that they also are unknowledgeable about the practice of medicine. They don't have a medical degree, and they have until now assumed that the DEA was right, that the DEA agents know what they're talking about, even when they're talking about medicine. That many judges disregard the opinion of the physician, but completely after 4 years of medical school, but completely accept the opinion of a DEA agent with maybe a few weeks training in this area.
And that's why we brought in a physician expert, a physician who was a practicing physician in a different state that gave opinion in the criminal court, in the criminal trial, and he said, y'all, what? He's from Georgia, and he says, what are y'all talking about? This is bread and butter psychiatry. What are you crazy y'all here in Pennsylvania? This guy is doing everything right, and the jury heard that. And he says, I have nothing in this case. I don't even know Dr. Rifai. I've never even met Dr. Rifai. But this is his care is exemplary. This is the right way to do things. And I guess the jury heard him, and the judge heard him. The judge heard that my care was exemplary. And so this is the record that the judge is working on, hearing in the criminal trial that I do things the right way. And now we're going to have a civil trial where the DEA is just dredging up this issue. And I think I told you, I think the railroad on this thing is going to end. They can lie and lie and lie and lie, and there's an end for the track, and then that train is going to go off the rails.
Why do you think they never just stop and say, we made a mistake, we thought it was this way? I would respect them so much if they ever stopped at some point during a prosecution and said, oh, we were told something that was false, or we thought it was one way and the evidence proves it was another. Here's why we were wrong. But they never do.
It's a chink in the armor. They cannot say that. They basically that will basically degrade their authority. This is why the DEA administrative hearings, the judge knows she cannot concede to anything. Every case needs to go the DEA way. A respondent cannot win. She knew that. She knows that. And their statistics is nobody wins in the DEA administrative hearings unless they say, oh, yes, I did a mistake. I'm sorry. I will do better. Here's $150,000 and I will do better. I will take 500 hours of CME, and this is the only way that they'll agree to settle with you. But if you say, I didn't do anything wrong, you folks made this whole thing up, no hearing for you.
Exactly. And that's the same thing with a lot of medical boards. You must admit fault or you will lose your license. Once you admit fault, then that is used by the DEA against you or by an appeals court to maintain your conviction.
Mm-hmm.
And but I think that they would have much more authority if they admitted to making human mistakes instead of inhumanely continuing to prosecute when they know they are wrong and when it's clear that someone is innocent. Because to me, they absolutely prove that they are knowingly trying to convict innocent people just to appear omniscient, which we know they're not. Everyone knows they're not except them, apparently. Would you, at some point, if they had come to you and said, we were wrong and we are sorry,
They'll never say that.
but would you have been able to move on and kind of
Sure. Yes. Yeah, I would move on.
uh, I think that is the greatest tragedy of everything that is happening right now, is that innocence is not an option. You must be convicted. You must go to prison. You must stand in court and show remorse for something that you did not do. And that's what makes this an inquisition. It's not an investigation, because they've already decided your guilt and they are just excluding anything that doesn't confirm to their narrow viewpoint of how they want things to be. Last question. Are they purposely targeting innocent doctors to terrify everybody? Because if you only go after guilty people, then most prescribing will continue the way it has been, the way doctors think it should be. However, if you start hammering clearly innovative, innocent people, you will absolutely shut down prescribing across the country, which is pretty much what they've done with opiates. And now it's moving into ADD medications and other types of controlled medications. Do you think that they're purposely targeting innocent doctors, or are they truly so incompetent that they can't tell the difference?
I think they're incompetent that they can't tell the difference. Number one. Number two, it's all about money. It's all about these forfeitures. I mean, now the DEA is so strapped for cash. And it's in news reports. They're accosting people on jetways in airplanes and taking their cash.
That's
I
right.
mean,
And an elderly physician who has worked up their life savings, worked for 30 or 40 years, they're going after these 80 and 70-year-old physicians, and physicians like you who are innovative and successful. I would argue that's why that 80-year-old man is in prison, so they could take his property, not
yes,
because he broke the law.
yes, yeah, yeah.
Dr.
They could
William
take his.
Bauer. Dr.
Yeah,
William Bauer
they
was
take his
just released.
property. What is it? $1.2 million in forfeiture, and that's it. They call it a day. They just made the budget for that DEA office for that area for the whole year. That's it. The salaries of everybody in that DEA office for that whole year. Plus they take, if he has cars, if he has anything, they take him and they ride him, and then that's it. Or they take him and they sell him, and then they buy vehicles for themselves.
It is to in my opinion, a type of organized crime masquerading as law enforcement. I know I only had you for an hour and you have responsibilities. Do you need to go?
Yes, yes. Thank you very much.
Thank you so much, Dr. Rifai, and please keep speaking out. It's wonderful to hear you.
Absolutely, absolutely.
Thank you, sir.
Take care.